Okay, good morning, everyone. I'm the last speaker of today, so or of this morning rather. Please bear with me, and then we all get coffee. So I will try to keep this brief and entertaining.
So you're going to take 45 minutes now?
Yeah. I'm going to take all the time. We have a discussion, of course, yeah. So as we heard from the three very interesting presentations before me in this panel, domestic law to one extent or the other, and in one way or the other, has very many interesting examples that can be instructive to us for the purpose of customary international law interpretation or ascertainment. So now I would like to take a slightly more theoretical turn and discuss with you today how can we learn from the interpretive practices of domestic courts for the purposes of customary international law interpretation. How I will structure this presentation will be by firstly going very briefly into the objective of my research and how I conceptualize customary international law interpretation for the purposes of this research. And then I will turn to the more operative part of the presentation, which deals with, on the one end, existing frameworks of interaction between domestic and international law, and then on the other end, my findings in light of these existing frameworks on what might be a working theoretical framework for this interaction between domestic and international for the purposes of customary international law interpretation. And then in particular, I will present this framework to you through two questions. Firstly, why should we learn from domestic practices? And then secondly, how can we do this? So in terms of the objective, for this particular presentation, the aim was to develop a working framework of interaction between domestic and international law for the purposes of identifying rules of customary international law interpretation. Then this is set, of course, in a slightly larger objective to build this framework over time as an integral part of my PhD research and within the TRICI-Law project. So this is very much a work in progress, and any type of feedback is truly welcome. Turning to the interpretation of customary international law, firstly, as some of us in this room know, this process is currently not regulated. So there are no VCLT-like counterparts for customary international law insofar as its interpretation goes. However, it is regularly engaged in by international judges. So I enumerate very few examples there, but I would be happy to also consider some questions on this during the Q&A, because we genuinely find the interpretation of customary international law in the practice of international judges. Now, turning to the academic element of it, there is an ongoing academic debate concerning the interpretability of customary international law. So, is it subject to interpretation? This debate is broadly divided along two camps. One, which says that customary international law cannot be interpreted, either because of its unwritten nature or because the process of identifying customary international law also ensures its content determination, so our job is done. Then on the other end, we have the other camp, which says that, well, customary international law, or interpretation of customary international law is a given. We accept it, we reference it in passing, and then it is what it is. We just observe it as a process. So this kind of unravels to us a limited research presently on the interpretability of customary international law, and this is also hopefully where the TRICI-Law project will come in with its findings. Now, I conceptualized the interpretation of customary international law through the visual aid of a customary international law timeline. Now, I know there was some debate on this yesterday, quite a lot, so I would be very happy to reopen this during Q&A. But for the purposes of this explanation, I visualize the timeline in the following way. We begin with the stage of formation, where the elements of state practice and opinio juris are ongoing, and I envisage this as a process of state practice and opinio juris that just amasses. We then go into the phase of identification, where there's an inductive analysis of state practice and opinio juris by a relevant judicial authority, and it is identified that there is sufficient evidence to establish that a customary international rule exists. Now, after this point in the timeline, so after a customary rule has been identified or ascertained into existence, if you will, we have some disagreement, or we don't necessarily have an explanation of what happens afterwards. I posit to you that we cannot claim that in this period, every time the rule is again referred to in cases, we cannot say that this is re-ascertained. So we cannot expect that every time judges go through the process of inductively analyzing state practice and opinio juris. So this is why I posit that in this phase, interpretation takes place. Now, of course, there's a question mark there because we don't necessarily know yet what are the parameters of this interpretation. Now, in the final element of the timeline, I envisage that interpretation also plays a role in the potential evolution or modification of a customary rule. Now, not every customary rule will go through this process necessarily, of course, but if a rule undergoes the process of evolution or modification, I posit that interpretation will play a role. So, turning to the more operative part of this particular presentation. For my research for this paper, I explored several existing frameworks of interaction between domestic and international law. Now here, I intentionally use the very broad term of interaction because I believe that it adequately captures the diverse ways in which the two legal orders, domestic and international law, relate to one another. So I've grouped my findings in three tentative categories, one being the vertical legal transplants, the second one being direct borrowing, and the third one being interaction as a cycle. I will go through these briefly in the interest of time, but I'm happy to answer more questions should they arise. So, in the vertical legal transplants framework, we have two dominant contributions. The first one by an American jurist, Wiener, in 2001, who borrowed this approach from comparative literature, which used the notion of law literature, which used the notion of legal transplants in a transboundary context, and then refined it for the purposes of domestic to international interaction. So Wiener tells us that legal transplants in this context are called vertical legal transplants, referring to the transposition from domestic to international, and he defines them as the borrowing of legal ideas from national law into international treaty law. Wiener analyzes this through the example of environmental law treaties, and he comes up with the conclusions that vertical legal transplants in this context are significant, conscious, and purposeful borrowing of legal ideas from domestic into international law. They are a careful selection of legal concepts, and then an appropriate adaptation into international law. So not ready-made transposition, but rather an adaptation of the legal concept. And then finally, that a big role is played by what he calls legal entrepreneurs. So in Wiener's analysis, these are NGOs and legal academics who consciously transpose these legal concepts from the domestic to the international context. This idea is picked up around a decade later by Dolezaj, who then refines it, and she calls it the borrowing of legal institutions between states and international law. In Dolezaj's analysis, this was analyzed through the example of the borrowing of the procedure of amicus curiae briefs from UK law into the practice of the European Court of Human Rights. So Dolezaj refines this framework, and she tells us that for a vertical legal transplant to be successful, we need a lawmaking opportunity. We need, again, norm entrepreneurs, but then she extends this category to also include lawyers, government officials, and civil society. And finally, we need access to the decision-making body. Turning to the framework of direct borrowing, what I have found in the literature is that this is treated as instances of domestic law being a tool for international judges. So in the work of Vanderbilt, this is analyzed through the example of international criminal courts and how they rely on domestic law. Now, I differentiate direct borrowing from vertical legal transplants because in the case of direct borrowing, this transplantation still remains very much within the framework of traditional sources. So Vanderbilt tells us that this is a plugging of, that borrowing happens to plug legal gaps in international criminal law, and that it happens through the framework of traditional sources, so either customary international law or general principles. We have the example of the two-step approach of the Furungia trial chamber from the ICTY, where the trial chamber basically took an approach of first engaging in a comparative legal analysis across various domestic systems, and then transposing their findings of principles to the international level. Another interesting example comes from Article 21, 1C of the Rome Statute, which deals with the sources of law for the ICC. And here this article tells us that domestic law has a supplementary role that kicks in insofar as international law is insufficient to cover a certain issue. Turning finally to the third framework that I've dealt with, the so-called interaction as a cycle. I borrow here from the work of Kanetake and Nolkamper from a phenomenal volume which deals with the so-called cycle of contestation and deference. And within this framework of interaction, there's an element of mutual learning between the two legal orders. So how Kanetake and Nolkamper conceptualize this is by saying there are domestic contestations towards international law, which invite procedural or substantive changes on the international level. Then, in response to this, international law gives deference to domestic law, and it incorporates a process of adjustment to respond to this contestation. Now, within this particular framework, I looked particularly into the so-called interfaces between domestic and international law that Kanetake develops, where on the one hand we have legal interactions or interfaces, so the traditional ones, customary international law, sources, treaties, and then on the other hand we have the non-traditional interactions, which are normative, conceptual, and political. And these are particularly interesting because Kanetake tells us that actually there are many ways in which domestic and international law can interact in a non-traditional way, and these include either analogous introduction of domestic principles, so by analogy into international law, transnational principles being transposed into international law, or even political influences from the domestic level somehow influencing the legal development on the international level. Finally, from this framework, I also borrowed the role of domestic non-judicial institutions that was developed by Urueña in the edited volume, which again makes a very interesting point about how non-judicial institutions from the domestic level can affect the development of international law. So, turning to the more operative contribution of this presentation. My first question was, why should we learn from domestic practices for the purpose of customary international law interpretation? I came up with sort of 4 answers to this question. Firstly, because learning from domestic practices gives us the benefit of already developed knowledge and practice. Secondly, because learning from domestic practices helps us achieve a more integrated system of international law by bringing the two legal orders closer together. Thirdly, because actually even empirically it has been shown that most of the interpretive canons that we use in international law originate or are traceable back to domestic interpretive canons. So either all the way back to Roman law or to more contemporary canons developed in civil law and common law systems. And finally, because I believe that learning from domestic practices for the purposes of interpretation, customary international law interpretation, also provides domestic judges with tools how to deal with customary international law in their respective jurisdictions. And then this serves a twofold role. Firstly, we give judges tools to deal with customary international law, and secondly, this practice of theirs feeds back into international law through the circular interaction. So, how can we learn from domestic practices? Much like the traditional rhyme I tried to incorporate in my title, and which tells us that for a successful marriage, we need all 4 components: old, new, borrowed, and blue. I believe that the best way to learn from domestic practices is by incorporating the approaches, several elements of the different approaches and the different frameworks that I presented to you today. So, from the framework of legal transplants, we take the conscious, purposeful, and acknowledged borrowing of domestic law. We take the element of adaptation, and we don't take ready-made concepts, but we adapt them to the sensitive international legal context. And finally, we take the reliance on norm entrepreneurs, and in particular, the role of scholars in conducting the relevant analyses. From interaction as a cycle, we take norms emerging from transnational judicial dialogue. We take the vertical dialogue between international and domestic judges. And finally, we take the role of domestic non-judicial institutions in the development of international law. And thirdly, from the framework of direct borrowing, we take the element of the comparative legal analysis, once again, the role of judges, And finally, national law as an openly acknowledged source for principles in international law as well, thereby arriving at what I tentatively call a framework of integrated learning across legal orders. Thank you very much.